Harassment and cyberbullying are often areas that come up. The Protection from Harassment Act of 1997 is intended to prevent stalking and other similar unsocial conduct. It states that a person must not pursue a course of conduct which amounts to harassment of another and which that person knows or ought to know amounts to harassment of another. The Malicious Communications Act 1988 makes an offence in England and Wales to send an indecent, offensive or threatening letter by use of electronic communication to another person. And there's an equivalent provision with regards to Scotland and Northern Ireland, and also with regards to telephone messages, as well as sending electronic messages. The Public Order Act of 1986 makes an offence for a person to publish or distribute material which is threatening or abusive or insulting if it is intended or likely to stir up racial hatred. And there's further provisions in the Racial and Religious Hatred Act of 2006 with regards to making threats based on race or religion. And the Crime and Disorder Act of 1998 creates an offence of racially aggravated harassment. In all these situations, we're talking about a criminal offence, and again, the guidance is to contact the police and deal with the police in dealing with the situation. Again, going back, it's the same story. The institutions are also under a duty of care, which means they must consider in each circumstance whether there is the possibility of harm or loss through harassment or cyberbullying, and take the steps that would be reasonable in those circumstances. There is one other area with regards to harassment and cyberbullying, and that is that there are various orders that are available to courts to ensure that a person's safety. For example, child protection orders. Institutions should be aware of these if they are applicable in relation to any students that they have, and likewise they should perhaps be aware that any pupils coming into the college from a school may be subject to such orders, and they may wish to liaise with the school with regards to suitable provisions as a result of those orders. With regards to harassment or cyberbullying in relation to disability, the Disability Discrimination Act of 1995 lays down particular provisions there, and there are particular safeguards. Finally, data protection. Your learners are going to come to the institution and provide personal data with regards to their identity, their contact details, perhaps even financial details, and also their progress through the course of study. So there's risks of identity theft. The personal data can be a gateway to physical abuse when someone knows another person's address, and bullying. So want to make sure that personal data is kept appropriately. The institution could face loss of confidence, legal action and potential now monetary penalty notices if it fails to comply with the Data Protection Act's duties. And it will also probably be the recipient of increased scrutiny as well if it's subject to data protection loss. The Data Protection Act 1998 deals with this area, and there is a large amount of guidance on it on the JISC Legal website. But in short, it's protection of information about an identifiable living individual. There's a duty only to process data under certain conditions for a defined reason, and you must ensure the security of the data. New technologies, especially social networking technologies and other Web 2 technologies, often involve submitting personal data. Compliance with the Data Protection Act should be considered before adoption of these sort of technologies. On the whole, you should have confidence in your data handling procedures and respect for your Data Protection Act duties in order to safeguard your learners. To sum up then, the law places a duty of care on each institution to ensure that its activities don't cause harm to others. Where you reasonably foresee that there might be harm to others if you don't take care, you must take the reasonable precautions looking at that situation in order to avoid the harm or loss. That is a very vague test, but one that must be considered, and risk assessment is core to working out what you should be doing to safeguard your students. Sexual offences and obscene publications are generally dealt with by the criminal law, and if there is a situation, you should contact the police to deal with that. And defamation, if you are running social networking tools or Web 2 tools in particular, you should be aware that if you get notice of a defamatory statement, you need to act to take that down quickly and investigate, or you could become liable as well. If you are moderating or editing a list, then you can be liable if a posting goes up. With regards to computer misuse, you have to make sure that your facilities are appropriately secure, and you have to ensure that any hacking is dealt with so as not to affect your learners. With harassment and cyberbullying, again, many of these areas are covered by criminal law, but beyond that, there is still the institutional duty of care to ensure that your learners learn in a safe environment. And finally, data protection involves the protection of data, or the personal data of your learners. For more in-depth information on any of these areas, please visit www.jisclegal.ac.uk.
Thanks for that, Jason. As you've heard there, in many cases the liability of colleges to protect learners relates back to the duty of care owed to them. Unfortunately, the issues are such that there might not be any definitive answer available. It will generally depend on individual circumstances and will require a judgment to be made by the college in risk assessment terms.